Okay. Hello, everyone. Welcome to the Sonia and Richard show. Today, we're just going to discuss a bit about wills and how they intertwine with trusts and how they both kind of work together. So, obviously, there are a few different types of trust there. The ones that we are aware of is the interest in possession trust, the discretionary, and the bare slash absolute trust. Richard, do you mind just kind of covering the purpose of that trust and kind of what are the situations for people to have a certain type of trust?
Yeah, like generically speaking, I mean,
Yeah.
so a bare trust or an absolute trust, as you say, is really just a very basic trust in its own right. Normally, would utilize it, for example, if someone had passed away, not necessarily, but if someone had passed away and they have young children, minor children, and the assets going to the children, then it'll go into an absolute trust or a bare trust, and then the trustee is just literally holding the asset for them until they reach the age where they can make a decision by themselves. The trustee has absolutely no power to, in terms of autonomy or discretion. They just sort of act in the best interests for the beneficiaries. The trustees, doesn't belong to trustees. They're just managing it on behalf of the beneficiaries until they reach the age where they say, right, I'd like it back now, can I have it for myself. And the trustees can't say no. So a situation would be like bank accounts, maybe savings accounts. That's a very common one where you might be saving for your child, with special savings accounts. I forgot what they call, like trust accounts or just interest-free accounts for children, but it's in the parent's name. Um, as soon as the child reaches 18, that they can say, right, I want it now. And the parent can't say no legally. So that's an example of an absolute or bare trust.
So is that kind of the most basic type of trust? Is it the
Yeah,
most
literally.
popular?
I mean, some people would argue it's not really a trust at all. They're just a nominee arrangement.
Hmm.
It has its place, definitely. It's just that the trustees really, a trust in its true form, the trustee should have absolute discretion to make decisions, withhold the asset for various situations or scenarios. So there's no asset protection per se over the age of 18. By law, especially for revenue law, it's deemed to belong to the beneficiary. So there's no ring fencing. There's no kind of protection of the asset as far as the beneficiaries are concerned. So really and truly, the trustees are not really doing the job as a true trust would be doing. It's just an arrangement to protect the children whilst they're young. So it's more of a nominee arrangement as opposed to a true adulterated trust, so to speak.
So are there any like potential drawbacks or disadvantages of having a bare trust?
Yeah, you wouldn't put your house in a bare trust. You wouldn't use a bare trust for asset protection, or protect it from, your children from divorce or generational inheritance tax or something like that. There's no inheritance tax benefits. Well, depends on what the planning you're doing, but in general, there's no inheritance tax benefit. The asset belongs to the beneficiary, so there's no kind of veil or protection,
Hmm.
or control for as far as the settlor, the one who creates the trust, there's no control at all. Um, so yeah, it's you wouldn't use it, if you're in the mindset of I need a trust to do X, Y, and Z. If it's not for a minor, and there's no kind of further planning required, and it's not the most efficient of trusts to use, put it that way.
Okay. So would you kind of use that trust in, let's say, quite a simple will?
Yeah. No, no, well, a simple will is normally the terminology will say statutory trust on
Hmm.
statutory trust, which is a bare trust or an absolute trust.
Hmm.
So most simple or basic wills would have bare trust in there. It just goes direct to the beneficiary. It's in their name, absolutely.
Hmm.
And really with basic wills or statutory simple wills, that's not the best planning.
Hmm.
So, for example, if the beneficiary is delinquent with money, they're spendthrift or just not very responsible. Maybe they're on substance abuse of some form, or they just got a history, maybe mental health scenarios. So they don't understand mentally how to just manage money well. they need a guardian or a representative to do that on their behalf,
Okay.
then the bare trust would probably be the worst type of trust to
Hmm.
use, because there's no legal precedent to just stop a trustee from giving them if they ask for it.
Hmm.
So if they're like desperate, I need to buy something, I want to buy a Ferrari with my money, and they have no need to buy it, the trustee cannot say no unless they're under the age of 18.
Yeah.
So it's really quite a poor arrangement.
Okay. Thank you.
That's all
So
right.
just to ask about a discretionary trust,
Yeah.
would you say that's quite popularly used type of trust?
I don't know how popular it is. I think it's the best type of trust to use. Obviously, depending on the scenario. Every
Yeah.
trust is for the scenario, but it's the most flexible type of trust,
Hmm.
certainly.
When you say flexible, what do
Mm.
you mean by that?
So it gives, because the trustee let me speak English. With a discretionary trust, it is as exactly as it says. The trustees have absolute discretion. Now there is a caveat to that.
Hmm.
It's down to the drafter. But if it's drafted well, then they would have a lot of powers, which gives a trustee a lot of opportunity to be flexible. So it's as if the asset belonged to the trustee as if it was their own, even though they only have control over it, they don't have ownership over it. So, and also for the beneficiary's point of view, they are not a beneficiary until the trustee literally calls their name and says, "Oh, now you're up. It's your turn." They may never ever be called as a beneficiary. Now, some people think, well, what's the point of that? But the benefit is, if they don't have use of the asset, beneficial use of the asset, then they don't own it. Now, things like divorce, bankruptcy, any kind of asset protection situation, if it's established that the beneficiary has use and some type of ownership, then that can be attacked,
Hmm.
especially for divorce, a nuptial settlement. Whereas if the trust owns it, so the trust has not distributed the asset to a beneficiary, because the trustee, in their wisdom, are trying to protect the asset on behalf of their instructions or wishes granted to them from the one that created the trust to set law,
Hmm.
then that's absolute protection. Okay, it's literally ring fence, because the trust owns the asset, not the
Yeah.
beneficiary have use of it. And the trustee can call the shots. They can loan funds, they can invest the funds. If the powers are granted to them, with a very well written discretionary trust, then it gives absolute flexibility. The other reason why we say it's flexible, we don't know what the future holds. We don't have a crystal ball. And if you give assets away absolutely today, in 20 years' time, the beneficiary is no longer alive, they die before the actual testator, the one that creates the trust or testatrix, or the will rather, or the scenario in the future that could never have been fathomed or imagined has taken place, it's too late. It's failed. You
Hmm.
can't reverse it. Whereas if it's in a trust, especially a will trust, the trustees can sit back and just assess the situation first and make a decision. Do we distribute it to the beneficiaries? Do we not? Is it, if the beneficiaries are not alive, well, who else do we have in the class of beneficiaries that we can direct the wealth to? Should we add an additional beneficiary if required? Maybe a family member was discovered that wasn't included. All these scenarios can be done. Shall we create a brand new trust? Shall we shut the trust down? The trustees have room for the maneuver. So hence it makes it very flexible, because you just don't know what the future holds.
Okay.
Yeah. So the protection is definitely robust.
Hmm.
Again, with the right planning.
Hmm.
Because some trusts, for example, if you get a free life insurance trust, yeah, they're discretionary, but the drafting is very limited. It's free. So the trustees may not have as much wide powers as a very well drafted trust from a qualified drafter. A solicitor is qualified to draft deeds, because it's a regulated activity.
Hmm.
Um, so yes, a solicitor can draft it. Someone who understands the tax side of things can plan it, um, and asset protection, etc. So that you at the end of the hero, the client, whatever their wishes on trying to achieve, if it's possible, can be achieved. And the trustees, if they understand how trusts work, um, and the tax regime, for individuals and for trusts, and even just the law, whether it's down to family law, corporate law, private law, revenue law, um, a whole range of laws that take place that can affect an individual, bankruptcy law or insolvency, then that can really make a big difference as well in terms of the planning.
Okay.
definitely. So
Okay.
the discretionary trust is a very powerful tool if it's used in the right way.
So it's one of the most powerful
I'd
trusts.
say it's, yeah, all the trust is definitely the most powerful.
Okay. And then that makes me move on to the interest in possession
Mhm.
trust. So that is not as powerful as a discretionary.
It's kind of like a quasi absolute trust and a discretionary trust mixed together. So the interest in possession trust,
Mm-hmm.
if I put the tax side to one side for a minute,
Mm-hmm.
um, basically allows the beneficiary to enjoy the income. So that could be a use of something like cash or living in a property.
Mm-hmm.
But the capital, so if it's a property, the house is locked tight by the trustee. They can't touch that.
Okay.
Yeah. So it gives that flexibility um, uh, for the beneficiary and also for the settlor to say, well, basically, it depends on what they want to achieve, would determine the type of trust that you'd set up.
Okay.
Is it a drawback? With unless it's drafted in the right way, the income, if you're looking at it from a tax perspective, is taxed on the beneficiary. So depending on the income, that's not protected in any way. So if they've got cash that they can just spend as much as they like, um, if it's a rental income or something like that, and it's a lot of money accumulate, that they're receiving, and it's not protected from divorce or bankruptcy or from business deals that's gone wrong, anything like that, they're taxing it from their personal rate of tax, whatever that might be. Um, and for inheritance tax purposes, it's assessed on their individual wealth as if they're the ones that own it. So there are drawbacks to an interest in possession trust. The capital obviously is ring fenced, and that can be directed to a different beneficiary once they call it I forgot what it was called now, the life tenant, depending on how many is set up and all that type of scenario. Then once that's exhausted, then the remainder man gets the capital.
Mm-hmm.
That in itself may not be a good deal because that absolutely goes to someone in their name. So from a generational wealth perspective, unless it's done written in a flexible way that it can be converted to a discretionary trust later on, then it really has its limitations, and hence it's down to the planner and the drafter to make sure it's done properly, depending on what you're trying to achieve. Because the problem with our world in estate planning is you're trying to please the client in terms of what they want to achieve. You don't want to waste or lose money through poor planning, i.e., taxation. And there's different taxes, inheritance tax, income tax regimes are different on the different types of trusts. If it's
Mm-hmm.
set up in lifetime, if it's set up upon death, it's a different income tax regime. Capital gains tax could be a potential problem depending on if it's during lifetime and what the asset is. And so we're trying to advise the client with all these plates spinning, well, what do you want? And ultimately, they have to make an informed choice, but you want to make sure that they have the best deal. And then also when it's passing down to their loved ones, that they don't get ripped off or a mistake has been made because of poor advice as well. So this is where the technicality comes in.
Yeah.
You have a lot of fun with it once you understand the rules of the game. You can play the game much, much better, but it's just making sure you get the advice so that things don't go wrong. Um, Hence why trustees are so important. Choosing the right trustees are so important. So there's no challenges down the line.
Okay.
Mm.
Thank you, Richard. So
Okay.
just to go back to basics, because this is something I would question.
Okay.
For anyone that's, new to this and is a beginner to this, will a will and a trust, do they have to be together when
Not
created?
necessarily. It just depends on what we're trying to achieve. Now, as far as we're concerned, as a business and our mission is purely on building generational wealth. And so we advocate having trusts within wills because it just creates that flexibility. It does create the opportunity to pass down wealth generationally, and protect the wealth from attacks from different directions based on other people's choices or decisions. Some people don't advocate that. So it's not a hard and fast rule to have a trust, um, like a specialist trust in the
Mm-hmm.
will.
Mm-hmm.
But if our target market, our ideal client really who we help 9 times out of 10 are business owners, or are quite affluent. So they have cash, they have wealth they've worked hard to achieve that wealth, especially if they're business owners. They've got shares that's accumulated value and or cash. So it's like, well, how is that wealth going to be distributed in the
Mhm.
most efficient manner?
Okay.
And the sooner that they start that planning, the better the decisions they can make going forward. So, and then obviously the wealthier people get, the bigger the team they need to help them plan that wealth. So tax advice is absolutely imperative. Financial advice is absolutely imperative. You need financial advisors who are switched on and
Mhm.
understand inheritance tax planning, not just investment and returns. Understand life insurance and its place. Understand the power of estate planning and how a team can just come together. And then switched on lawyers who understand the law under
Mhm.
certain situations that could be quite unique, whether that's under revenue law or bankruptcy, insolvency, family law, divorce, etc., prenuptial, blah blah blah. It goes on. So ultimately, the will is just a foundation. It's not all that we do, but it's a foundational step that will set up the next generation and future generations in a much better place. And especially now with the transition of wealth is a massive, potentially high. We're in a baby boomer at its peak. Generational wealth coming down is going to be huge. Um, so and the next generation, however young they're going to be, may not understand that accumulation of wealth. You heard that story of from shirt sleeves to shirt sleeves in 3 generations. Let's make it 20 generations. But without the planning, the wealth could be lost
Mhm.
inadvertently and unnecessarily. And then one of my biggest bugbears is generational inheritance tax. You pay inheritance tax once, then this generation down don't do any planning because they weren't taught. And so they're paying tax on the same asset twice or even 3 times, which is shocking. So just to stop that, and it's in its own right for me, a well drafted will make a lot of sense. Lifetime planning, depending on the wealth size, will make a big impact as well. So yeah, I feel like I'm
Okay.
waffling a bit, but ultimately that is so important.
So that leads me to my next question.
Mm.
I've seen, in our TikToks, a few people have asked, "Can I write my will myself?" That's something you wouldn't advise.
I'm not a fan of it because it's so easy to make a mistake. If you don't know the rules of the game, you can't play the game properly. And we're in an environment where most of the rules are in plain sight. But if you don't know where to look, the best way to hide something is put it in plain sight. It's like when well, for me anyway, when you want to buy a car, you find your ideal car. You think no one's driving that car. You pick the color, you pick the model, and for you it's perfect. And as soon as you made that decision, every time you look outside, that car is going past you
Mhm.
because your brain is now switched on. It's looking for it. Your subconscious is,
Yes.
is tailored for it.
Mhm.
Your frame of reference is opened. It's the same thing with knowledge. If you don't know what to look for, you're not going to find it. And so, writing the will yourself, if you don't know the rules,
Mhm.
how are you going to draft a very well crafted will? If you've got an expert who knows the rules, understands the scenarios, understands the situations that can occur, that has occurred in case law, how to bypass it or avoid it altogether, um, and keep it flexible so you're not, every 2 minutes having to rewrite the will, or something like you get married a week later thinking that
Mhm.
you've got a will when it's completely revoked. You just didn't know the rules. Who's going to spend their time understanding, estate administration and
Mhm.
unless you're just super passionate about it. So
Yes.
hence it doesn't make sense in my world, in my mind, to draft your own will if you have no idea about the rules of the game. It's like me going to play chess. I'm not a chess master. Why would I be sitting down playing a chess game if I don't know how to, to represent
Yeah.
England and I have no idea how to play the game that well? It's the same concept.
So, what's like a common mistake a lot of people make when creating a will? What do they miss out, or what is usually an issue when it comes to probate with a will?
I think the biggest challenge with wills is people don't understand that it's not just a piece of paper. It's not just a tick box exercise of,
Mhm.
oh, I've got my will, I'm sorted. Behind the covers of the front page of a will explain a lot. And 9 times out of 10, it's a very basic will for a relatively complex estate. So I see people with wills and they have an intention to do something like, for example, only this week I spoke to a client. Um, their child is married. The partner's living in her house with the child, um, and they're worried. Like, well, if they pass away, does the will do a job to stop the partner from getting the money from their child. Now, and again, it sounds like I'm going to have a dig at solicitors. I'm not, but unfortunately, they're not all specialists. They're generalists. Okay, so you need to find a specialist who understands how to draft wills. Um, and so, looking at the will drafted by that particular solicitor, there was no inheritance tax planning, and the lady has, the wealth is over £500,000. It does not cover the scenario that she's concerned about. She says she's been chasing the solicitor for a long time, and no one's come back to her. They were referred to us. She said, "Well, you're 99.5% answering my question," and we just put a trust in the will, but it's done in a way that the daughter will not inherit until both move out.
Okay.
All right, and it's so important that, and she's happy with that planning.
Mm-hmm.
So it's not because it says a will on the front. It's like when you go to a restaurant, you can order. What's your favorite meal, Sonia? I don't know.
I don't know, sushi.
Sushi, and you can go to a sushi restaurant on the high street, and you go to a
Mhm.
sushi restaurant in Harrods, and they may taste completely different. It may taste a lot more fresh, and the ramen might taste really great compared to the high street, takeout. So it's the same thing.
Mhm.
How it's prepared, the planning behind it, it's not the same. Um, and most of the time, you get what you pay for. Yeah, it's not a matter of cheap wills. It ticks the box. I'm sorted. It's if you have a situation and you really want to make sure that your family are protected in the right way according to your wishes, because the
Yeah.
scenario is unique to you or you're uncomfortable, you need to get the advice.
Mm.
And it may be a will, may not be a will, but you need to get the advice so that you're on the right side of the law, in terms of succession law and how wealth is distributed. Other common problems is things like people own properties jointly, and they don't think ahead. So properties in joint names, um, one of the spouses pass away, surviving spouse remarries, but because the house is in joint names, 100% of the house goes in one person's name rather than the wealth
Mm.
separating. Now, if the children are both of theirs, no problem. But if they get remarried, if the survivor gets remarried, and the survivor passes away, number one, the fact that he got married, the original will that they had is completely revoked, null and
Mhm.
void. That then falls to the default government standard will.
Mhm.
A government standard will says, well, the first £322,000 of wealth will go to the surviving spouse.
Mhm.
If a new spouse who's not related to the children in any way, shape, or form, and maybe it's a predatory marriage, and like, well, he's got a house or she's got a
Yeah.
house, I'm going to marry him. They just got £322,000 out of a £500,000 house.
Mhm.
Then the rest of the wealth is split 50-50, absolutely, between the children and the spouse. So they've got almost three-quarters of a house for nothing, and the children are completely disinherited.
So sorry to cut you off,
Mhm.
but a lot of people don't really take all of this into consideration,
Exactly, that's the point.
and it's just like, well, a lot of sometimes, not a lot, but we tend to have a few people ask us, how much is it
Yeah,
to create a will, or how
yeah,
much is it to set up a trust? But you can't really put a figure in it because you have to kind of analyze the whole situation, their estate, the people they live with, the people that want to give a share to,
hmm,
if they have any businesses, if they have properties abroad. Like there's a lot to kind of consider.
exactly.
So when somebody asks about price, what would you say to them?
I say, it's not that I'm trying to hide how much we charge. We're very transparent. Our prices are on our website.
Hmm.
But I don't do business as a commodity, so I don't like quoting a price, because the mindset of the person. I'm being plainly honest. The mindset of the person asking that question, and I can tell immediately if the first question out their mouth is how much it costs. You're not interested in planning for wealth. You're interested in planning for price.
Hmm.
And I am not a commodity business. I refuse to operate as a commodity business. Go elsewhere, and I'm blatantly honest about that. If you're concerned about, well, I need the job to be done, um, and I say, well, this is a job that needs to be done. Um, this is how it will work. and here's the price.
Mm-hmm.
Now you can take a choice of in what all I can do is recommend. You decide how you want to go ahead as a client. I'd normally gauge the price in between 1% to 3% of the value of your wealth. Normally it's much less than 1%. But it just depends on what you're trying to do, especially if you've got lifetime planning involved. It isn't a bulk up the price. But if you spend 5, 6, 10 grand and you've got £1 million estate, that's less than 1%. Why would
Mm-hmm.
you be arguing over 1 or 2% to save 98 or 99% of your wealth? That's an investment.
Mm-hmm.
Yeah, you'd probably spend more than that on a holiday if you're that affluent. So the question is, it's all relative. If you're a business owner and you want to, and it's important to you,
Yeah.
then money is not an issue as long as it's doing the job.
Mm-hmm.
And I don't care about how wealthy you are. Wealth is relative. Ultimately, it's if you want a problem to be solved, we can help you. If you're just like shopping around, tire kicking to get the best deal, I can't help you
Yeah.
because that's not how we do business.
Okay. Thank you, Richard.
That's all right.
So I'm just trying to think. Another question to ask you actually.
That's all right. All right.
Um.
I think the long and short of it is, wills, trusts have their place.
Mm-hmm.
I know we're going to be talking about, risk assessment in terms of mental capacity and things like that another time. Lifetime planning is super important. When I say lifetime planning, because the will is fundamental, it's just the surface to stand on. But if you've got a lot of wealth, over £1 million as a family, the inheritance tax is where it's a big concern for a lot of
Mm-hmm.
people. So property owners, property developers, investors, business owners, whether that's commercial property, regular trade, whatever that might be, need to have a serious conversation because if you're a business owner in a partnership or with multiple directors and there's equity stakes that, and the family are not involved in the business, what happens? The business is under threat unless you plan during your lifetime. So much things to discuss. Trusts as well with business owners
Yeah.
is a bit difficult because when your wealth hits a certain level, trusts are not always the most efficient tools to use. So you would use other vehicles in a trust-like operation. So corporations are very powerful and flexible tools to utilize because you can manipulate the shares, manipulate the memorandum and articles. Um, and with the right planning, you need a competent advisor and solicitor to help you with that.
Mm-hmm.
But then you can achieve the wealth. And normally, we're talking about like £4 or £5 million plus estate to achieve something like that because the costs are quite high.
Yeah.
So it has to be worth the while. But ultimately, these are important. If you're a farmer, so important. There's so much relief that can be claimed. That the tax HMRC have definitely put in place for business owners who have trading businesses, non-land based, investment based businesses, but they're trading. If you're an investor with lots of cash or shares, again, trying to, depending on your age, we take that into consideration to plan in advance. And trusts work on a 7-year cycle. And most people don't have 14 or 21 years to wait to reduce their wealth by, £1 million over 21 years. Effectively, that's just too long. So, what other ways or vehicles or approaches are there to help? And this is where a level of sophistication and having the right team behind you comes into play.
Mm-hmm.
I know trust is a buzzword, but they can be pejorative to the wealthy or the
Yeah.
affluent. They have their place. Don't get me wrong, but there's other ways. There's other things. It's just for me, it's the mindset of own nothing, control everything. I
Mm-hmm.
know we're called once, but once you have that in mind, then you can find vehicles that will work in that remit. A trust is just one of them. A will is just another one.
Mm-hmm.
A corporation is another one. There are, different opportunities that are available. Again, depending on the situation. If you're offshore, another scenario. If you're a resident here, non-resident, again, we start to get ballooning into different scenarios.
Mm-hmm.
Hence, you need competent advisors to guide you.
Okay. So this episode, I kind of wanted to focus on wills and trusts a little bit, but it's
Yeah.
kind of pushed me to this next question
Okay.
regarding lasting powers of attorney. So you did briefly mention about, financial property protection. in relation to the wills and trust, but how does the LPA kind of protect the property and financial affairs LPA? How would
Yeah.
that be advised?
Well, I see LPAs like a will for your lifetime.
Mm,
From the point of view that a will, since we're talking about wills, only becomes active when someone dies.
mm,
Now, you could draft a will today and someone won't die for another 20, 30, 40 years. Now, that's fine. So, and then you could put property into trust. That's a property into trust. But then what about all the other things? So, bank accounts, decisions if a property, if you've got multiple properties that need to be
mm,
sold, distribution, just decisions regarding your finance
yeah.
and property are important. So you need someone who you trust and understands your circumstances to be able to sign off on those things.
Mm-hmm.
Same with the health and welfare. I know you might ask specifically the property and finance, but yeah,
Mm-hmm.
it's imperative. I can't even put like what's more important. The will's important, but
For
the LPA is vital.
so the will is basically important for after life and then
Yes,
before or during
exactly,
lifetime, the
exactly.
lasting power of attorney.
Because people don't realize the will only kicks in when someone dies,
Mm-hmm.
and you got all these things that can happen during lifetime that a will just won't, and people are not aware of it.
Mm-hmm.
And that's the frustration I think in our world is trying to get the message out. Here's what we do, what
Yes.
we're doing to allow people to really take action.
Mm-hmm. And just to mention, as I know, you don't have a next of kin over the age of 18.
Mm.
So if you don't have an LPA in place, if anything was to happen to you, God forbid,
Yeah,
and you don't have an LPA in place, then decisions for you would be left to the court of protection.
potentially, yeah, because the family could the family decision.
Mm-hmm.
If an LPA is not in place, the local authority or the medical professionals can veto
Mm-hmm.
the family wishes.
Mm-hmm.
That's why I say there's no such thing as next of kin over the age of 18.
Yeah.
And yeah, and you go to court protection, and their remit may be far less or a lot more restrictive than
Mm-hmm.
what an LPA could provide. And most of the time they'll award it from memory for the health and welfare side of things, but not for the finance. So it's even more restrictive for families.
Mm-hmm.
Um, if it is the finance, it'd be very, very restrictive. And so
Yeah.
it's just trying to make sure you get the right experts.
Mm-hmm.
I always say prevention is better than cure. The pain of sacrifice is far more better than the pain of regret.
Mm-hmm.
And so it's taking that action, even to be informed. That's why education for me is so important.
Yeah.
Be informed so you can make the choice at the time when it's necessary, rather than being reactive because something has happened or you're trying to prevent something from happening, and which it could be too late, to take any action at that time. So yeah, it's a whole argument of education
Yeah.
that to me is important, and it's not taught in schools.
Mm-hmm.
It's just not promoted, generally speaking. The industry in general is very much like shielded. Go to a solicitor, go to a professional, then pay money, and then we'll tell you. It should be. We're in an age now that information is commoditized.
Yeah.
You've got AI, but if you don't know what questions to ask with AI, you're still going to get garbage in, garbage out. So you still got to get the right
Yeah.
information in order to get the better information later on. So it is so important. Education, financial education, to me is imperative.
Oh,
Really, really, really.
well, thank you.
Thank you.
So next episode, we're going to go into more detail regarding LPA's last power of attorney. Just discuss basically how helpful it is and how important it is
Yeah.
to really have one, as we briefly discussed. So I think that'll be it for today.
Perfect. Thank you so much. I appreciate it.
All right. Thank you.
Cheers.